Hey guys, so the Supreme Court of India recently made headlines for ruling against a woman seeking an abortion at 26 weeks. But before we get into details, make sure that you like this video, subscribe to our channel if you haven't already, and hit that notification bell if you don't want to miss any of our videos. Okay, so a 27-year-old mother of two who claimed to be suffering from postpartum depression among other health issues approached the court requesting to terminate her pregnancy since she was emotionally, financially and physically not in a position to raise the child. While the court had initially granted her permission, it was later recalled based on the advice given by a panel of AIIMS doctors. The doctors stated that permitting the abortion at this stage would be stopping the heart of a viable baby. This would be the same as feticide. The other option would require the petitioner to undergo an emergency C-section and prematurely deliver the baby. However, the doctors stated that this would potentially cause the child to develop abnormalities. This is what ultimately led to the court's decision to reject the abortion request. The decision was in line with the Medical Termination of Pregnancy Act 1971, which allows for abortion after 24 weeks only when there is a diagnosis of fetal abnormalities or if the termination of pregnancy is needed to save the life of the mother. CJI Chandrachud, who led the bench, raised several moral concerns about the situation. According to reports, the CJI is supported to have asked what was she, the mother, doing for 26 weeks. She already has 2 children. She is not a rape survivor, she is not a minor, and she is aware of the consequences. Why come now? Senior advocate Colin Gonsalves is reported to have cited contemporary international law to show that the unborn child does not have a right and that the right of the pregnant woman is absolute. He also cited previous cases where, under the guidelines of the Union of India, it is permitted to stop fetal hearts in third trimester abortions. To this, the CJI replied, "Do we issue an order for the child's death through a judicial ruling? Can she get rid of the child even a week before delivery? We need to look at the rights of the unborn child." The court also stated that if the mother had a normal delivery, it would be easier to give the baby up for adoption. If the child is born with deformities now, no one will want to adopt, the Chief Justice said. Since there was no threat to the mother's health and the baby did not show any signs of fetal abnormalities, the court denied the plea for an abortion. So, an initial look at CJI's responses might make it seem like he's pro-life and defending the rights of the unborn. However, when looking at the questions in more detail, it's easy to see the hypocrisy of his position. Let's look at the different objections to the abortion request one by one. So, the first objection that is raised is that the mother is not a survivor of rape. If she was, then it would be fine to go ahead with the abortion since she was not consenting to the pregnancy. We've seen many such cases in the recent past. In January, the Delhi High Court allowed a 14-year-old rape survivor to terminate her pregnancy at 25 weeks. Another such case took place in August when the Supreme Court allowed a rape survivor to abort a 27-week-old baby. In 2017, the Supreme Court even allowed a 13-year-old rape survivor to abort a fetus at 31 weeks even though there was nothing wrong with the child. For all of these cases, it was determined that the trauma caused by the assault was sufficient reason to permit an abortion, even though they were well past the 24-week limit set by the Medical Termination of Pregnancy Act. This raises the question, does the viability of the child in the womb become irrelevant when it is the product of rape? Does the manner of conception take priority in determining whether or not an unborn child has a right to life? Did the CJI only reject the woman's petition to abort the 26-week-old child only because it was conceived in a marriage where the husband and wife intended to stay together? Would this same child have been aborted if it was conceived as a result of rape? While rape is a horrible and devastating crime, it doesn't justify abortion. The woman is definitely the victim of a heinous act, but so is the unborn child. Neither should be punished for the crime committed by the rapist. We've covered this topic in a bit more detail in another video. You can check it out using the link in the description. The next point the CJI brings up is that the woman is 27 years old and not a minor. She clearly knew what she was getting into and what the consequences of her actions would be. Again, the Medical Termination of Pregnancy Act allows for unmarried women to terminate pregnancies arising out of consensual relationships. This was what happened last year when the Delhi High Court granted permission to a minor who was in a consensual relationship to terminate a pregnancy of over 18 weeks. So in this case, the CJI states that since the woman is old enough or mature enough to understand the consequences of her actions, then the unborn child should not be punished with death. But if the mother is a minor, then she is just a child and so cannot be forced to continue the pregnancy. The minor may or may not have understood the gravity of her actions and the seriousness of of what she was getting into in her relationship. However, this should not have any role in judging whether or not the child born out of such a relationship should be permitted to live or not. In allowing the minor to get an abortion, essentially, one child's life becomes more valuable than the others. The two major reasons that ultimately led to CJI's decision was the absence of any threat to the mother's life and the absence of fetal abnormalities. To be clear, there is no health condition a mother could have that calls for an abortion in order to save her life. There are illnesses that could require surgeries or other forms of treatment that as a consequence end the life of the unborn. However, the major difference would be that for such treatments, the primary goal is to treat a condition or illness, while for an abortion, the primary goal is to murder the child in the womb. There is no illness that is treated by solely killing the child. Again, we've covered this in a bit more detail in another video. You can check it out using the link in the description. On the other hand, we have cases where various tests show that the child could be born with some kind of deformities or mental impairment. Such was the case last year when the Delhi High Court allowed a married 26-year-old woman to terminate her pregnancy at 33 weeks after an ultrasound at 30 weeks revealed a fetal abnormality. While a mentally or physically impaired child might be difficult to raise, it doesn't mean their lives are less valuable than a perfectly healthy child. Such children have equal dignity and worth. Some people claim that they get an abortion for the child's sake to prevent the child from experiencing unavoidable suffering and a life of struggle. But what does this actually mean? To prevent them from going through life which, despite the difficulties, could still be fruitful, dignified and worthwhile. You kill them and remove the opportunity to live at all. How does this make sense? How is killing such children the dignified option? Finally, we have the age of the fetus. This seems to be a very tricky and difficult one for people to come to an agreement on. How far is too far? 20 weeks was expanded to 24 weeks. This was increased to 25, 26, 29, 31 and even 33 weeks based on the circumstances. How do you determine when the child becomes a child? According to the MTP Act, the upper limit for most cases is 24 weeks. Even in the latest case, the CJI said that since the fetus was at a gestational age of 26 weeks, the court cannot order the killing of a child. So does something magically happen at 25 weeks? How does the same fetus which was not considered a child at 24 weeks suddenly become an unborn baby at 26 weeks? And if this is the case, why are abortions allowed at 29, 31 and even 33 weeks? Shouldn't it be considered the brutal murder of a child then? The reason for this confusion is just a denial of basic science. Human life begins at the moment of conception, not 2 weeks, 2 months or 6 months later. The moment the sperm and egg fuse to become an embryo, life begins. The human created in the womb at that moment is as worthy of life as the baby that is more fully developed. A human does not gain dignity as it grows or progresses in life. Regardless of the circumstances of the baby's conception, the baby's health, status, their age or the mother's feelings about her pregnancy, the unborn's right to life must be protected unconditionally. So, what do you think about this? What circumstances could justify abortion? Should the ultimate decision to abort lie with the mother? Let us know in the comments below. Also, if you like this video, let us know by liking and subscribing to our channel. It helps us a lot. Until next time.